Hi, this is Amy Palmer Laracilla, an attorney from Standpoint, and those of you attending are listening to Advocacy Skills for Addressing Sexual Harassment in the Workplace. Ty, are you there to do the intro?
Yes, I am. Good afternoon and welcome. I'm Ty Sinavan, Advocate Support Program Manager here at Standpoint. Today I'm going to be assisting Amy and Tracy with the questions part in today's webinar. So if you have any questions, just type your question in the questions tab of the control panel, and Amy and Tracy is going to be checking in with me periodically after each section of the presentation to answer any questions that you have. Also, in your panel, there's going to be a section called handouts. And in that section, there is a PowerPoint that Amy and Tracy have created for this webinar. So please feel free to upload that and print it if that is more helpful for you in taking notes and following along. And as always, this webinar is being recorded and I will be uploading it to Standpoint's YouTube page in the following week. We have many more helpful webinar recordings on our YouTube page for you to listen to and view when it's convenient for you. Some of the topics we have on there are illegal advocacy, order for protections, harassment restraining orders, common evidentiary issues in order for protections, family law advocacy, immigration advocacy, housing rights, confidentiality, and a whole bunch more topics that are really relevant to advocates serving victims of domestic violence and sexual violence and trafficking. Um, our webinars are prepared specifically for advocates, so if there is a topic you would like us to present on, please let me know. And also subscribe to our YouTube channel so you can get notifications when we upload videos. That's all that I have, Amy, for now.
Wonderful. Thank you so much, Ty, for that intro. And yes, as Ty mentioned, please do feel free to make this as interactive as you are interested in doing. Type in questions, comments, anything that you'd like to add to the discussion. Tracy and I are more than willing to engage with you folks, which we know is sometimes hard to do over webinars. So please do write in as you are able and interested. So yes, hi, welcome. Thank you all for attending today. My name is Amy Palmer Laracella. I am one of the 5 attorneys here at Standpoint, and I have a background in employment law as well as civil tort law for survivors of domestic and sexual violence, and also those folks who've experienced sexual harassment in the workplace. I recently joined Standpoint in large part because of the increase in calls we were getting about workplace rights and the role that the workplace has in responding to folks who are experiencing harassment there. And so I joined in February, and it has been an incredible experience so far. And I encourage you all to please do continue to reach out to Standpoint. We are always happy to entertain your calls. Standpoint provides free legal advice and consultation and advocacy services to anybody in the state of Minnesota who's experienced domestic sexual violence, sex trafficking, labor trafficking, or harassment in the workplace. And so we run an action line. You'll see at the end of this presentation our contact information. We always encourage all of our advocacy support systems around the state to reach out with any questions they have, as well as survivors directly. Tracy, do you want to introduce yourself and say a little bit who you are?
Sure, thanks, Amy. Hi, everyone. So my name is Tracy Thomas Card. I am the Advocate Support and Grant Manager here at Standpoint. I recently joined the Standpoint team a few months ago. And over the last year, I would say I've had the opportunity to do a number of trainings, both for nonprofit and for-profit corporations on sexual harassment in the workplace. I think it's an issue that we are starting to see more and more as advocates. And so Amy and I are really hoping today to provide some support to all of you as advocates doing outreach and awareness around the services that you're doing for sexual harassment and the information that attorneys might need to know.
Great. And before we get started, let me please just apologize quickly for the delay. We started a few minutes late because just because I'm an attorney and have had some advanced education does not mean that I know how to plug a cord into a laptop appropriately. So we were trying to navigate some of those technical issues and appreciate your patience with us while we were doing so. Gonna need to figure that one out so I don't have to talk to the boss about that one after this call. So yeah, just to get us started, we're really, as Tracy mentioned, we're seeing a lot more, an increase in terms of both community discussions as well as folks who are actually targets of harassment that are reaching out for support services from advocacy. So what we wanted to do today is just give you kind of a broad overview, talk a little bit about how we view sexual harassment on this continuum of violence that a lot of the time is very connected to folks' gender, gender identity, sex, sexual orientation, and how advocacy is really in a particularly advocacy is well placed to be hosting some of these community discussions, support various employers in your communities that are doing these trainings and trying to, connect with them as resources, and then also really thinking through the role that advocacy might have as it relates to individual targets of harassment and how they might be able to do some more support. In large part, the increase for Standpoint in calls on sexual harassment and workplace rights has stemmed from the hashtag #MeToo movement. For those of you who are not familiar, in late 2017, Alyssa Milano tweeted out a request for all of those who, what would it look like if around the world, everybody who'd experienced harassment in the workplace or sexual assault just responded with the hashtag #MeToo. And it really went viral and became this sort of rallying cry for those experiencing violence as a tool of oppression. And many women, many men, transgender individuals, gay individuals, all of them started responding that they also had experienced this violence and this harassment. Me too. But I think it's important to note that this movement really did start over a decade ago with activist Tamara Burke, who, when working not in the violence movement, but when working with youth and youth who were struggling in schools and in her community in Brooklyn, she started to hear this recurring theme, speaking with all of them, that they also had been experiencing violence and sexual assault in particular. And so really started to focus in on, okay, if we were to be able to really unearth this and talk openly about this, and how do we really focus on those that are experiencing it and moving to a place of attempting to heal, what does that look like? So it's an important reminder that this is not a new fad. This is not just a current trend. This is something that's been going on for decades. So with that, I think let's dig in. So for today's objectives, we've got kind of an ambitious agenda for all of you. We are going to be addressing the impact of violence in the Me Too era and looking at it in particular as it relates to workplace harassment. We'll be talking with all of you and engaging with you on how to identify workplace sexual harassment, because this is something that is very intangible and looks very different depending on the context in which it's happening, depending on the industry in which it's happening, who the parties are, all of those sorts of things to consider. Talking through some strategies to respond to sexual harassment, and recognizing areas where advocacy in particular can play a role in not only individual advocacy support, but then also engaging the communities in which you work to really end this, this tool of oppression that's being used in our workplaces to keep people out of them.
And we wanted to let you all know that we are able to schedule more detailed webinars on or trainings on any of these topics if that would be helpful to you. You just need to let us know. We also do want to do a pronoun disclaimer. So most of the clients that Amy has worked with have identified as women, but we know that sexual violence and sexual harassment affects people of all identities, all genders, and so we are cognizant of that as well. And so we just want to start by tossing out a question to know who is already engaged with their communities or local employers on any of these issues regarding sexual harassment in the workplace.
If you all could just respond in the chat box if you are, that would be really interesting to see, and maybe just list out either the county in which you work or the program you work for. That'd be helpful. And then Ty, if you don't mind just reading back any of the responses that you're getting.
Sure. When I see the responses, I will read them off.
We'll wait just another minute or so just to see if folks respond. And I'm going to assume if people aren't, then that means that they are not doing this work yet, which is okay. Okay, so moving right along then. Go ahead, Ty.
I was checking the chat box and things popped up in the questions box. Okay, so I show here the Aurora Center, and Katie in Hennepin County at SVC. We're engaged in community as it pertains to sexual violence, but not specifically to the workplace.
Okay, that's helpful context. Thank you to those of you who responded to that. Yeah, we're seeing where a lot of advocacy organizations are having these, this community engagement and these conversations within their communities about sexual violence. And they may be even talking about some workplace rights and things, but it's still fairly infrequent that we're seeing sexual harassment in particular being addressed. So this should be good. We're excited. So today I just want to make a quick kind of distinction and help folks understand exactly the kind of sexual harassment that we're going to be talking about. So we know as advocates and attorneys that sexual harassment can occur in a lot of different contexts. It takes many different forms. There is harassment that happens in schools. There's harassment that happens just in public on the streets. A lot of people reference that as catcalling. I personally like to use the language of street harassment because I think it actually honors the severity of what's happening rather than kind of minimizing the acts of yelling at individuals because of how they look or how they're representing themselves and how they present. And so there are definitely areas where there are laws that control there. There are things that we can do and ways that we can get involved. But to ensure that we're able to give all of you folks a good enough sense of what's happening in the workplace, we're going to focus today just on sexual harassment in the workplace because it's a particular framework of law that applies. And there are some nuances there that may not necessarily carry over and apply in the same way as like harassment in the education context. So let's identify it quickly, and I'm not going to get too much into the legal detail because I just, I don't know that it's all that relevant to our discussion today, but just to give folks a framework. So sexual harassment is a form of sex discrimination. It violates a number of different laws. As I mentioned, in the employment context, it violates Title VII of our Federal Civil Rights Act. It also violates the Minnesota Human Rights Act, which also controls in the context of employment. But as I mentioned, it also violates Title IX, which many of us are familiar with in terms of the Title IX process that's happening at school, in schools, as well as potentially violates a number of other criminal or civil laws that we have in place in our communities. I think it's important to note that the terminology sexual harassment is actually not contained in any of the laws anywhere in this country. Sex harassment is not something that's explicitly prohibited. It is framed in the context of discrimination on the basis of sex. And so the framework that's really come out in terms of how courts look at this is very much based on that view of discrimination on the basis of sex or sex orientation or gender, and how that impacts both the conduct that's occurring and then what occurs for the individual afterwards. The behavior does not have to be sexual in nature. A lot of the time, the sexual harassment claims and calls that we get are not explicitly about sex, but instead are about the use of gender or the use of sexual orientation. And this is a framework that all of us are very familiar with in the context of power and control over another individual and how that impacts them. So just to remember, or a reminder, it doesn't have to be about sex or dating or something like that. It also could just very well be about the person's gender or orientation. All right, so next handy little graphic here. And I just say this to make sure that folks have an understanding that there are a lot of different laws that are coming into play when we're talking about discrimination. So in the employment context, we have many laws in this country that prevent discrimination on a variety of bases. Sometimes it might be because you're differently abled and you're being treated differently. It could be because of your age. It could be that you deserve equal pay because of your gender. But today, the one that I want to focus on is this one right up at the top, that Title VII of the Civil Rights Act of 1964, and then this one on the right, Minnesota Human Rights Act. These laws prohibit a ton of different kinds of discrimination. As you can see in that circle, we've got race, creed, color, religion, sex, age, disability, marital status in particular, status with regard to public assistance. All of those things are prohibited by these laws. But the things that we're talking about today will be sex discrimination, marital status discrimination, sexual orientation, or familial status. I also think it's important to remember that, so we had our Title VII framework come about in 1964. There were a lot of different practices going on in 1964 that would certainly be against what is acceptable today. But I think it's important to note that it wasn't until 1986 that the Supreme Court, actually recognized sexual harassment as being included and incorporated into Title VII. So we have had this framework for quite some time in our country, right? So since '86, this has been prohibited. But as many of us have seen over the past couple of years, there's still a whole lot of very egregious conduct going on that is not yet being addressed by our laws. So looking at sexual harassment in the workplace, we obviously have a number of different kinds of workplaces represented on this slide. We have office contexts, we have medical field, we have more construction or manual labor kinds of jobs. What I can tell you from representing both employers as well as plaintiffs, targets of sexual harassment over the years, it happens everywhere, and it happens in all kinds of workplaces. So there really is not one workplace where sexual harassment is less likely to occur. It still happens across all of them. And so folks that say, oh, the practice of law has certainly made it that, attorneys are much more equipped to respond to this and sexual harassment doesn't happen there, that's a little bit bogus. It still happens all over. So just to sort of set the stage and the context.
And I think too, from an advocacy perspective, we often are working with victims who are experiencing harassment or stalking outside of the workplace. I think oftentimes it's a gap area for advocacy agencies that victims may not know that they can also reach out to your agencies, your advocates, to get support for sexual harassment in the workplace as well. So thinking about how to develop and strengthen relationships with companies in your area about the services that you provide is going to be really crucial to this.
All right, so the next slide is depicting two different situations that span the course of 25 years or so. And unfortunately, from looking at it on its face, it seems that not a whole lot has changed. But what I can tell, I'll summarize a little bit for you all and show you the direction that our country is going with this law. So the two individuals on the left here, we've got Clarence Thomas and Anita Hill. And these pictures are from the 1991 Senate Judiciary Committee hearings as it related to the nomination of Clarence Thomas to the Supreme Court. And what ultimately happened, for those of you that maybe weren't even alive when this was occurring or who were perhaps very young and don't have the memory or the recollection of it, is Anita Hill used to work with Clarence Thomas when he was at none other than the Equal Employment Opportunity Commission. For those who don't know, the EEOC, the Equal Employment Opportunity Commission, is the federal body that is tasked with investigating charges of sexual harassment that people make. So it's interesting that he then was publicly examined himself for committing sexual harassment. And what ultimately occurred is, in these Senate Judiciary hearings that were very public and transmitted across the country, similarly to what just occurred earlier this year, is Ms. Hill recalled incidents where Thomas, who was her superior, had professed his interest in bestiality porn, had been talking about long dong silver, females with large breasts, men with large penises involved in sex acts, a number of different, very offensive, very derogatory conversations. And ultimately, she ended up being the person who was publicly vilified for what she was saying. Many people didn't believe her. And for those that did, many just shrugged it off as, oh, it's not that big of a deal. That happens everywhere. And I also think it's important to note that, the people that are currently very active and proponents of our movement and allies in our movement, none other than at the time Senator Joe Biden, was very much a part of that vilification process. And so it's just important to remember we have all come a long way in 25 years, but we still have plenty more work to do. One of the good things that came out of this very public Senate Judiciary hearing process is it gave word and voice to what many people were experiencing around the country, but did not have language for. So talking about sexual harassment in this way had just not really been done publicly up until 1991 when she came forward. Unfortunately, it was a sacrifice that she had to make to move our, to get our movement to move forward. But it is one that really did have a tangible impact, because the EEOC reported in the 2 to 3 years after Ms. Hill testified, they did see a very significant increase and uptick in the number of folks reporting sexual harassment in the workplace, as well as were able to actually, do some mediation and some settlement of many claims that would not have otherwise ended up before them. So there was a very real benefit to what she did. It's just she ended up suffering quite a bit for it. And then on the right side here, we have a picture of Roger Ailes, the late Roger Ailes, and two of many women who came forward and accused him of sexual harassment and sexual assault, really, in the workplace as well. Gretchen Carlson is one of them. She's the one on the left. And then when she first came out in about 2016, very few people paid attention to her story and gave her the time of day, and many just brushed it off or didn't believe her. But it wasn't until then Megyn Kelly, who's depicted here on the right, came forward and said, yep, this is happening to me as well, and these are the details of it. It was only at that point that people started to pay attention. And one of the things that was really unique about this situation is it unearthed a practice that has been going on in corporate America for quite a long time, for decades, of paying survivors and targets of sexual harassment a certain amount of money to buy their silence. And they're called non-disclosure agreements, NDAs, if you've heard of them referred to as that, NDA, non-disclosure agreement. And ultimately, in the exchange for some monetary compensation, the target, the survivor of sexual harassment, agrees to not speak about it publicly. And what was happening, while that on its face is not necessarily problematic and may actually be a benefit to the survivor if he or she wants to move on and work in a different environment and not have this story follow them around, what was occurring is that not only were they entering into these NDAs over at Fox News, where Roger Ailes was the chairman at the time, they also then were not taking any action against Roger Ailes and others that were doing things like he was doing. So they were effectively silencing these targets of harassment without taking any look or evaluating any of their practices or limiting the exposure that other employees of theirs had to a predator. And so there's a large movement around the country now that is looking at enacting legislation that would prohibit these kinds of NDAs, except for in the context of when a survivor themselves wants it, but still requiring some kind of accountability on the part of the company to make sure that they're doing something with the individuals so that they are not just sexually harassing with impunity.
I think in addition to celebrities, we are reading and seeing more about workplace sexual harassment in many different environments, not just high-profile environments. And so if we take a look at recent headlines, female janitors working the night shift take safety into their own hands. Everyone missed a key reason that there are so few women leaders. And then if you look over to the right side of the slide, Target employees claimed sexual harassment and that management didn't stop it. 266 sexual harassment complaints filed in state agencies. Renaissance Festival faces sexual harassment, hostile workplace suits. So the three headlines on the right are right here from Minnesota. The other three are national headlines. And I think oftentimes when we are talking to community members about workplace sexual harassment, it's very easy to envision the high profile cases that we read about and see on the media, but it's often much more difficult to envision it taking place right here in your communities.
Yep, and going then to this next slide here in looking at workplace harassment and how and why it is so underreported, in particular in industries where it does involve a certain amount of lower paid individuals, more less education in terms of the number of people that are involved in it, that sort of thing. They are even at more risk to experience sexual harassment or even sexual assault in the workplace and not be able to connect with anybody for support resources or even report it. And a lot of that has to do with a distrust of HR, where they see human resources role as to protect the company and doesn't necessarily have the employee's best interest in mind. And I have to say, as having represented many of the human resources side of things for a number of years, that's not inaccurate, unfortunately. Human resources certainly is there to provide resources to employees, but that does have a limit because the human resources departments in many instances, not all, I don't want to say all, but in many instances, their role and their responsibility is to really limit the liability for a company. Sometimes limiting liability is aligned with the target's interests, and that's great, but it's not always the case. So just understand that as you continue to work with survivors of sexual harassment and they do decide, let's say they do decide they want to report to HR, it is absolutely okay to be honest with HR. They will likely, be able to conduct an investigation and take action the more information they have, but also just to be somewhat wary of the intention behind some of the things that they're doing, and just know going into it that they are not an automatic ally. And that's okay. You still may have resources that you can get from them. You still may be able to work with them and cooperate with them, but just to know that ultimately their interests are not aligned automatically with the target of harassment. Another reason it's so very underreported is that there's just a fear of retaliation. And I'll talk a little bit more in the presentation about what retaliation looks like, but just being scared that you could be fired, demoted, punished for reporting sexual harassment. And that's a very valid fear. We have a lot of evidence that shows that many people experience retaliation, either in the shape of negative consequences from their supervisor, or even just colleagues that don't believe them or are targeting them. So that plays a large role in why they don't report. And then, in my opinion, one of the reasons that is something that we very much can change very easily is bystander apathy. Oftentimes when it comes to sexual harassment, as opposed to sexual assault, perhaps, there are witnesses to what's going on. There are people that are part of these conversations, that are sitting in these meetings when comments are being made, or that are at the parties where some of this stuff is going on, and they don't say anything in a lot of instances. And I'm not even talking about intervening and actually interjecting in the conversation, but there is very little follow-up that's done with the targets to say, hey, I'm just checking in. That was really uncomfortable for me. Are you okay? Very rarely does that happen, and that is a huge reason why people don't come forward. So we're almost to the non-legal part here, but just to help sort of all of you as you're thinking through and working with clients who may be experiencing sexual harassment, I want to identify the two different kinds that are legally prohibited by our laws, by Title VII as well as by our Minnesota Human Rights Act. So we have two different types. There is the quid pro quo sexual harassment, and that basically translates this for that, meaning a term or condition of employment is contingent upon either the acceptance of some kind of unwelcome sexual behavior or a choice not to do something, right? So comments I've heard that are akin to quid pro quo harassment is, if we were together, you'd have so many more career opportunities, right? That is a veiled message of, I am expecting something sexual from you in the right context. And if you don't do that, there is also then this potential withdrawing or withholding of opportunities if you don't sleep with me. For a long time, individuals in my role on the employment side weren't really thinking this was happening anymore. They believed that we were getting to a place in our workplaces where the explicit, if you don't sleep with me, I'm going to fire you, wasn't happening. But what we have come to really realize, in large part because of the Me Too movement and so many people coming forward and sharing their stories, is that the quid pro quo type harassment is absolutely still going on. It's just much more veiled. It's not quite as direct. Sometimes it doesn't even involve a lot of conversation, but it may be actions and it may be coercion in that way that is used against somebody who has less power. So just be on the lookout for that as you're talking with your clients about what they might be experiencing at work. Because in a lot of instances, in particular, if there's a sexual relationship going on and one that was not entered into completely willingly, that absolutely would qualify as quid pro quo harassment. And then the other type, oh, do you want to jump in, Tracy? You're okay? All right. So then the other type is hostile work environment harassment. And I would argue that this is a little bit tougher to recognize when it's happening, because it's more subtle and it's more about the environment in which the abusive comments or behavior are occurring. And so this is a little tougher. I included a couple of descriptions from just my practice. I used to represent a number of different medical facilities, and this is not uncommon. The language that you see down here, where surgeons are talking about popping in some double Ds, talking about weekend trips to the strip club, describing various employees by their physical characteristics rather than by who they are or using their names. And then this was not my case, but it was one that just really struck me when I heard about it, is bringing in a former Playboy bunny for basically a fake interview just to have something to talk about afterwards and joke about, because it was so clear she would never get that job. And what I like to stress with advocates in particular is, think about, when you're talking with your clients, think about why what they're saying, the inappropriate jokes, the inappropriate gestures, how they're not, they're not necessarily automatically on their own in isolation a problem, but when they are spread out and they're pervasive in the environment, that's really damaging, because it really creates an environment where if people are being dehumanized, if they're being objectified, it really undermines the competency of any of the folks that are working there that might identify with that person. So even if I myself am not a target of sexual harassment, but I know that somebody who is similar to me is absolutely being targeted for it, it also still undermines my ability to contribute to the team and my value and what I bring to the table. So just things to think about.
Does anybody have any questions at this point?
No, no questions so far.
Okay, thanks, Ty.
Good deal. All right, so we're not going to be showing videos today, just because you all, all of you folks obviously have access to the internet for the most part and can go on and look at these and view them in your own, in the privacy of your own offices. But we wanted to just flag a couple of different videos that we find to be really helpful tools to thinking through what harassment does look like, and then ways to kind of identify it with your clients as they're talking about it. So I included a little image here. It's from a series that RAINN, RAINN, National Sexual Assault or Sexual Violence Organization, put on, where they issued a series of videos. Some are shorter, some are longer, where they really are trying to identify, yes, this is harassment for folks, because it is hard to tell and it's hard to know. And in particular, if you are the target, it's not a position anybody wants to be in. So a lot of people do try to brush it off because they don't want to be the quote unquote person that overreacts to it. They'd rather just get their work done and pretend it's not happening. So I think these can be effective tools to use to help folks to identify it. This one in particular is a situation where it's happening between two coworkers that work in the bar industry. The male identifying person is asking the female identifying person, so it's your first night. I can hear, you might have some issues. We've got some people in here. Guys get really aggressive. They might call you names or make references to language. And ultimately, what this individual does is, in sort of covering it as he's enacting what might happen later when she's working, he harasses her and then ultimately assaults her when he sticks his tongue in her ear at the end of the exchange. And so looking at things like commenting on somebody's appearance, in particular, he says, "Oh, whoa, 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 sorry, didn't mean to offend you. Thought you might be going on some kind of feminist rant here." Some of those sorts of things that are just derogatory and offensive, when you look at them in all, in a holistic way, really do amount to sexual harassment.
And I think this is something that we as advocates can relate to. We know oftentimes clients come into our offices seeking services, but not quite knowing exactly how to identify what's been happening to them. And so if you as advocates can have examples of the different types of harassment that we might see in the workplace, it can help your clients to identify what's been happening to them as problematic.
And then so what I've included on the next slide, so in that video, he makes references to people being at surfing camp and that being hot, and bikini bottoms falling down, it being a sausage party in the bar, you're a sexy girl, Sam, yeah, you're welcome, because she said thank you to that. All of that kind of behavior is concerning and would make somebody very uncomfortable. And then as advocates, it might be important, and it would definitely be important for if you were to do a consultation with an attorney afterwards, looking at, did that person have any seniority over Sam as they were having this conversation? Was that person her supervisor or manager? If it wasn't maybe a manager, is it still somebody who has a control over the scheduling and he's continually scheduling her at the same shifts as him, or has the authority not to schedule her if he has control over how many shifts she works? Those kinds of things also as many of you understand and know, really contribute to the power that this individual has over Sam. And then just really digging in with your clients on what the effect is of what those words that were used or the actions that that person had taken. All of that's really helpful context.
Okay, and the next section, we're going to talk a lot about the obligations that employers have, which I think is helpful for advocates to know when they are getting questions from clients who may be victims of sexual harassment in the workplace.
Absolutely. So you'll see on this next slide here, I think many of us can relate to this. If anybody has taken a sexual harassment training in the past decade, once you've taken that training, a lot of the time, the only thing you learn is really how to be a sexual harasser, right? Like you don't really get a lot of helpful context or information about what to do if you are harassed, or other than just how to report it, right? It doesn't necessarily, and usually it's getting better. Sometimes they're starting to involve this, but it usually doesn't incorporate any training for, what coworkers are supposed to do if they're seeing it, how they might be able to intervene or disrupt it, right? We are starting to see this more and more, thankfully, now, as bystander intervention is a concept that is starting to make its way into the employment field. But for a long time, you would literally just be watching a video of like an old dude groping a young person in the workplace, and everyone was like, okay, yeah, I know that's not allowed, but how do I deal with the rest of what's going on at work? So just a really sassy baby meme here for you to get us jumping forward.
Okay, so when we are thinking about what can or should an employer do if they have an employee that's come to them to report that they're being sexually harassed in the workplace, we can think about two different strategies, one being prevention and the other intervention. And we'll talk later on down the road about strategies that you can use when you're doing trainings on sexual harassment. But when we're thinking about prevention, we're thinking about stopping the behavior before it starts. So thinking about having clear and transparent policies in place, not just putting them in the employee manual, but making sure that all of the employees are aware of those policies. So not only who do they report to, but what does that reporting process look like? It's doing things like training your employees in responding to sexual harassment claims, to intervening to prevent sexual harassment from coming about in the workplace, from establishing those norms that make it okay. And it's not just a one-time training. I think oftentimes we see employers reach out to advocacy agencies for training for maybe an hour on sexual harassment, but the reality is we know it has to be more of an ongoing training, a comprehensive sort of education for employees at that workplace. Establishing effective sanctions. So we know that holding folks accountable is one way to prevent other instances from happening. Making sure that the reporting process, again, is clear. There are a lot of times when we are working with victims who aren't aware of their reporting process. And even if they are aware of the reporting process, maybe the steps that they have to take to make sure that that process is official isn't clear to them. Maybe it's not clear to them what will happen once they do report, what will happen not only to the victim, but what's going to happen to the person that's harming them while that investigation is taking place. I think engaging every worker at the agency to take responsibility is also a good way to set up a norm where it says sexual harassment in the workplace is just not acceptable here. And then if we look at the other side, looking at interventions, so of course an employer can and should immediately do some sort of investigation if they are receiving a report of sexual harassment. So we can liken this, those of you that are working with campus sexual violence victims, we can liken this to the Title IX process in which schools are obligated to investigate when they know that sexual harassment is taking place. Taking appropriate corrective actions. So disciplining the employee who is causing the harm, and whether that is disciplining them and allowing them to remain in the workplace, or whether that's disciplining them and terminating their position with your company. Restoring lost benefits and opportunities. So we know as advocates, oftentimes victims are experiencing a multitude of symptoms as a result of the violence that occurred to them, and that might mean that they are missing work or missing out on other professional development opportunities. And so the employer has an obligation to restore those benefits and opportunities to that employee. Again, disciplining the perpetrating employee and or supervisor, and then making sure that there's no retaliation against victims. We know oftentimes victims are afraid to come forward in the first place because they are afraid of that retaliation. And so ensuring that you have clear policies against retaliation and ensuring that if retaliation is taking place, that there is a swift response to it will help victims feel safe in coming forward.
Yeah, these two buckets of prevention and intervention are actual legal obligations for the employer. Now, I would argue there's not great guidance out there that actually requires them to do certain things within it. But, each one of these buckets generally is absolutely something that should already be happening. And it can look a lot of different ways. So I get questions a lot of the time from advocates being like, well, so when I was working with the survivor and they reported that they were experiencing sexual harassment. The company ended up bringing somebody in from the outside to do the investigation. Is that okay? Is that normal? And honestly, what I can say is that there really is no normal. There is no expectation. The investigation has to be done. Some companies do it internally with their human resources department. Some people do it externally. The only thing that really is required is that it be fair and objective. Sometimes it can be a benefit that it's kept internal, where the people actually understand the nuances of the work and they understand the work that's going on and the players involved. Sometimes it can be a challenge for the external entity, whether it's a consultancy or a law firm, to really understand what they're looking at and the dynamics. So it just depends. And also, unfortunately, there's really no the requirement is just that there is a reasonable response, a reasonable investigation within a reasonable amount of time. And so sometimes it can be a matter of weeks, sometimes it can be a matter of months for, depending on how long it takes the company to do so. And that can be really challenging for targets. So just talking with them as you're supporting them through this, staying in contact with HR as it's occurring is totally appropriate and okay, but also knowing that the target is not automatically entitled to the information that HR receives. And so that can be a real challenge for survivors and for targets of this, because they don't automatically get a chance to respond to what is being said to HR or to the investigative body. The other thing I just want to mention here in this no retaliation against victims and taking corrective action, even if a report of sexual harassment is not automatically, it takes time to investigate. If the report is severe enough and it's impacting the survivor's work enough that they need to be separated, that absolutely should be something that goes on right away, immediately. And it should never be the victim, unless the victim wants to be the one that gets moved. It should never be the victim who has to change their behavior or their working style in order to have an investigation go forward. I get a lot of calls where somebody complains about sexual harassment. HR looks and says, this seems like an internal personal dispute. I'm just going to move you to the other side of the floor, or I'm just going to change your schedule, and that takes care of it, right? That's not an appropriate response, because it negatively impacts the survivor, who then has to change their behavior and does nothing to inform the person who's actually doing the harassing that they need to stop. So give us a call if you have questions about these things. And like I was saying, so in terms of retaliation, we look at these as sort of, some of them are intangible, but many of them do result in actual tangible benefits being lost in your job. You might get a low performance evaluation, which ultimately results in you missing a promotion the next time around. They might transfer you to a less desirable position, spread false rumors about you, making your work more difficult if you're under increased scrutiny by your supervisor, demoting somebody because they've reported harassment. Those sorts of things are what we oftentimes see as retaliation, and they are explicitly prohibited by law, and it is up to the employer to make sure that those are not happening. So if things like this are going on, definitely give us a call. And here's just another slide that gives you some information on how often retaliation happens. Like I said, Sexual harassment is very underreported, and retaliation is a huge, huge reason why 75% of targets of harassment report that they've experienced some form of retaliation after the fact. That is major to have 3 out of 4 people say, I experienced some kind of negative consequence at my job. And it makes it almost impossible for you to stay and continue to work there. And that's why this next stat I have, 80% of women who've been harassed leave their jobs within 2 years. That is actually a huge cost to the employer. And a lot of employers that we work with, and that if you start doing engagement with and training with, they'll respond to that because they know it costs them money when they lose folks and they don't have a workforce that's stable and consistent, because they then have to train somebody new in. They might continue to lose people because they still have those individuals that are harassing in the workforce, right? So there's a lot of different arguments we can take and angles we can take in working with our employers that are in our communities, and just something to think about moving forward. This resource down on the bottom, I just want to flag for all of you. So Workplaces Respond, they've done a lot of work on, rights of victims of domestic and sexual violence in the workplace, and in the past year have really ramped up their efforts on the sexual harassment. Oop, I see a typo there. Sorry, gang. On their sexual harassment resources. So they've got a lot in there. If the workforce is unionized, they've got a lot of great information about unions in there, things to help employers address sexual harassment, and in particular, directly for advocates who are starting to do this work. So I encourage you to go to that website, the Workplaces Respond to Harassment website, and look at those advocacy resources. So we're going to shift to a little bit of the individual kind of response here and how they support individuals who are experiencing sexual harassment. And when you're talking with these individuals, really focus in on helping them to identify the details of the harassment. If what they're experiencing is hostile work environment harassment and it's spanning the course of years, it's going to be difficult, and they're going to need to piece it all together before they go and report to anybody or speak with anybody about it. So really trying to identify who's involved, when was it occurring, where, how often, why do they believe that it was going on? All of those questions are going to be things that an advocate can prepare a target of harassment to answer and help really build a case around it. So when I talk about reporting, yes, you have the right to report to your human resources department about it, right? That is something that HR is tasked with handling. If the harassment that's happening is harassment because a supervisor is the one that was doing it, or somebody in some position of authority over that person who's the target, automatically the company had a responsibility to ensure that wasn't going on. So if that's happening, there are a number of different places that an employee can report harassment beyond the company. And those, at least the 2 main administrative bodies who oversee these kinds of complaints and claims, are the Equal Employment Opportunity Commission, the EEOC that I referenced earlier, where Clarence Thomas used to work. They enforce the federal law, Title VII, prohibiting employment discrimination. And then we have the Minnesota Department of Human Rights here in Minnesota that enforces our Minnesota Human Rights Act. And both of these bodies are administrative in nature. They accept written complaints from people who are targets of sexual harassment, as well as other kinds of prohibited discrimination. And then they will conduct an investigation and they adjudicate basically this administrative process to determine, is something happening? Is there grounds where we could actually sit down and mediate this and get this taken care of before it gets out of control? And beyond that, if it's necessary, there could be lawsuits filed by either of these organizations too on behalf of an individual if there's a really egregious situation happening with the company. Know that you have to, in order to bring a lawsuit for sexual harassment or any other discrimination claim, you have to report to one of these 2 entities first. It is a bar to litigation if you do not go and first file with them. And unfortunately, that filing needs to happen typically within 1 year of when the incident occurred. So the Minnesota Department of Human Rights is a little bit longer. It's 1 year, whereas the EEOC is only 300 days after the incident or many incidents occurred. And just know that, that is something that's really challenging to navigate. So if you're talking with individuals who have experienced this, keep that time limit in mind. And if you have concerns about that, give us a call and we can talk about how to deal with it. I'm not talking detail about the flow chart here, but this is just something for all of you to have and look at. There are a lot of different ways that this administrative process can go when they do an intake, all the way through to some level of determination or conciliation. Ultimately, know that even if the Minnesota Department of Human Rights or the EEOC, even if they determine there's not enough here, there's no probable cause, discrimination likely didn't happen, even if they say that, you will still get a right to sue letter, because we want to still make sure that folks get their day in court. So even if they determine that they can't, maybe they don't have enough time, maybe they don't have enough resources to investigate, maybe they just don't think it happened, they'll still give you a right to sue letter so you can get into court. And now this is something that I do a lot of consultation on, and this is a place where advocacy in particular, I think, will relate with, as well as can do some damage control upfront with targets of harassment. So when moving forward with filing a report or with filing a complaint, or then eventually with filing a lawsuit, there's a lot of delayed recovery and healing that goes on because the process, can take years to get all the way through. There's a very significant lack of privacy that a lot of survivors experience, both survivors of sexual assault as well as harassment too. And ultimately, that can be a huge barrier to proceeding with a case if you don't know about it ahead of time, because there will likely be attorneys that are defending either the actions of the harasser or defending the actions of the company, saying this really wasn't this bad. It was because you have other things in your past, other assaults you've experienced, and that's why you responded this way. A lot of different, very invasive, very challenging conversations can happen. I included a clip here. It's an image from deposition testimony in a lawsuit that was filed. There was a woman of color in New York. She was the vice president of investment banking in a New York office from 2013 to 2014. She sued the bank in federal court for sex and race discrimination. And ultimately, during her deposition, by the company attorneys, this is an environment where they talked a lot about women's breasts and rating them and picking up cougars at the bar, talking about the sizes of their genitals, speculating on sexual activity of other traders, talking about everyone else's sex lives, right? Some just really crass, demeaning, derogatory commentary. And during her deposition, they went in and asked her to recount a sexual assault she'd experienced as a freshman in college 25 years prior, talking about how that incident was relevant to how she was impacted by the office, arguing that they needed to know what she believed counted as sexual abuse in order to talk about sexual harassment, right? Just some really invasive, very personal questions that had no relevance to what was going on. Because it's a civil proceeding, there is a large leash that attorneys are given to try to find relevant information. And so this was just one way where it really negatively impacted the person who'd been targeted. And so it's re-traumatizing. It can be very stressful, and it's costly too. It takes time and money to put these cases forward.
So ideally, we would love for employers to be reaching out to advocacy agencies for support and for training before any incidents take place, but very often we are seeing them after an incident has taken place in the workplace, and then sometimes employers are going into panic mode, wondering what they can do to prevent this from happening again. So the few pieces of advice that we would give them first and foremost would be to connect with their local advocacy agencies. And this is something that as advocates, you yourselves are able to do outreach for, just reaching out to local employers in your area to let them know of your services. Oftentimes, again, I think employers don't think to connect with advocates because they don't think that advocates are able to provide support for sexual harassment in the workplace. And the reality is that's just not true. Again, providing all employees and supervisors with comprehensive training. So very often we will onboard new employees, we'll read through policies in the employee manual with them, but do we actually sit down as supervisors and employees and think about what would happen if there was sexual harassment going on in our workplace? How would we respond to that, both as coworkers and also as supervisors? And again, regularly reviewing and being proactive about your policies and practices. So do you have policies and practices in place from 20 years ago, or are you sitting down and regularly reviewing them to make sure that you are keeping up to date with, for instance, technology is used often as a tool by harassers to harass victims. And so are your policies reflective of the use of technology in the workplace? So the next few slides are going to be pretty obvious for advocates, but our hope is that you can take this information and use it in terms of doing outreach and awareness to the employers in your areas. So one of the biggest questions they're going to ask is, what can advocates do? We know that advocates can provide clients experiencing harassment support in a variety of ways. For instance, employment advocacy. So again, if if a victim has to miss work, can we reach out as advocates to that employer to gently explain why that might be the case? Can we do safety planning with the clients experiencing harassment, particularly true if an investigation is ongoing and both the victim and the harasser are still at the workplace? How are we making sure that that victim feels safe? Can we do referrals to counseling or therapy in the area? Providing silent support during meetings with human resources, supervisors, or during mediations that are requested. And then also providing silent support during meetings with police, attorneys, and in-court proceedings. Definitely providing options to the victims for reporting. And as we all know, there are many different options, one of them being not to report at all. But again, as Amy mentioned, there are a few different options to report sexual harassment. So thinking about the different forms of advocacy that you can provide and advertising those services to employers will be crucial in raising awareness of your services.
Additionally, I think it's something that advocacy is really well placed to communicate with employers is we see the effects of sexual violence and sexual trauma on individuals, and we know how that impacts them in their daily lives. A lot of employers, I don't think, realize that targets of sexual harassment experience anxiety, depression, PTSD at a really high rate. So it is actually having a really serious impact on their workforce in a way that goes well beyond just the participation of one individual. But there's some really good statistical evidence out there that we have individuals that oftentimes, if they are the target of harassment, they are bending over backwards to change their behavior, and very, very rarely are they able to really escape it without fully removing themselves from that person. And even then, they still have some serious long-term effects in terms of anxiety and depression. So just trying to communicate and connect with them in that way can be helpful.
Okay, and so when we're working with victims who are experiencing harassment and are planning to report it, we want to make sure that we are talking with clients about their options. So options could include confronting the harasser, reporting to human resources, speaking to an attorney, or speaking with a counselor or therapist. Supporting the client in documenting. So while advocates, of course, don't tend to document a lot, and that's a good thing. If a victim is planning to report harassment to an official source, say HR or to the police, then they do need to have documentation. And when we're talking about documentation, it is much the same as if we are working with a victim of harassment or stalking outside of the workplace, in that we want them to document dates, times, as much as they can remember, how they were feeling during that interaction. And being able to support the client during the employer investigation. So we had mentioned when you're talking with different employers about the different types of advocacy that you can provide, one of those is that silent support during an employer investigation. I think keeping in mind that there are strict time limits to report and file with EEOC or MDHR is really important as well. Oftentimes, clients won't want to report immediately after they have experienced harassment and may wait often, like we often see with victims of sexual assault or domestic violence. There may be reasons that they're not reporting right away. And so just keeping in mind what the time limits are for them to make reports with the various agencies is important. You can always contact Standpoint along with your client to talk about signing waivers of rights to sue, to talk about entering into non-disclosure agreements. Amy had mentioned those earlier, that many employers try to make victims enter into those agreements. Before your client speaks to the media, oftentimes we know that victims want to speak out as part of their healing process. We also know that could potentially jeopardize a case that they may have against their employer. And so we just want to make sure that the clients that we're working with are completely informed of their options, so they have that power to make a choice of how they want to move forward with things.
And now before we switch slides, I just want to point out this website down at the bottom. I am obsessed with it because I think it is so well done and it is so easy to use, and it is something that's actually geared towards the targets of harassment and allies who are trying to assist them. So it's called betterbrave.org, and they have sections that are either for the targets of harassment or for allies or other resources on where to find help. And they just do a really great job of walking folks through what harassment looks like, helping people to identify it, thinking through ways to document, some helpful suggestions and tips on how to prepare your narrative and your story, and then really just explaining, the process. So obviously, when we're working with our clients, a lot of the time they're overwhelmed. They are not going to retain everything that we are telling them in that specific moment. This website can be a really great one to share with them to just look at on their own time as they're able, because it does a really great job. So in particular then, as we're talking about a harassment lawsuit, this is just another kind of quick primer for advocates, things to know. Yes, they do have a right to personally file a lawsuit, assuming that they've gone through the administrative EEOC or MDHR process. You want to try to empower them when selecting an attorney. A lot of folks are really wary of communicating with their attorneys, and they don't ask a lot of questions of their attorneys. And a lot of the time, the calls that we get from advocates, it really is, it's something that we can't necessarily help with because it really is a breakdown in communication between attorney and client. I always say, and this is a downfall of our current legal education system, but we don't get trauma-informed representation in law school. It doesn't exist. It is unfortunate that it doesn't exist because I would argue every single attorney, regardless of what their practice area is, could benefit from it, but it's not there. And so a lot of the time these attorneys, they're really wanting to do the right thing. They're vehemently representing their clients, but they just don't know how to talk to them and communicate in a way that is understandable and respectful. And so helping with some of those communication processes can be a really large benefit that advocacy can provide. And again, to the extent you do have a client that's going through a lawsuit, you may not be there every step of the way, and that's totally okay. But knowing when those really significant touch points are of if they're sitting down for a deposition, knowing that they're going to likely need to talk to somebody afterwards to really process the questions that they experienced, the victim blaming that they went through, thinking through some of those in advance to help them prepare might be really helpful too. And then this resource down at the bottom, the National Crime Victim Bar Association, is just a really helpful resource for folks that are just looking at what civil options they might have.
And I think too, Amy, you had mentioned that advocates can help their clients to select attorneys. I think it's important for advocates listening in on this webinar to know that once a client has an attorney, our Standpoint attorneys can't talk to that client because they already have representation. But what they can do is talk to the client and their attorney together. So if the client that you're working with has questions about the process or what their attorney is doing, the attorney and the client are more than welcome to call Standpoint and do a consultation. So I know that when I was first doing direct services, I was extremely surprised sometimes at the interactions that my clients were having with attorneys. And it was because I didn't understand the type of information that attorneys actually need to move a case forward.
We're really needy.
And so I think as advocates, it's really crucial for us to be able to explain to our client why attorneys might be asking the questions that they are. And so I'm going to break it down into two main types here. One, they're going to ask questions about the event itself. And two, they're going to ask questions about the damages sustained by the victim. So when they're asking about the event itself, they are likely going to be asking about things like the date and time of the criminal occurrence, the location of events, addresses, and descriptions of the premises, perpetrator identification or description if that's unknown, how the perpetrator gained access to the victim, questions about the identification of witnesses to any stage of the occurrence, the identification of any known physical evidence. They're going to ask whether a police report was filed, whether there was criminal case information filed, and whether there's any third-party liabilities. And then when we are thinking about questions they might ask related to damages sustained by the victims, the attorneys will likely be asking for things like medical information. So the degree of physical, emotional, and psychological injuries that are sustained, the extent and cost of anticipated treatment. They're going to ask about the identification of the hospital and the physician services, the identification of property damage. They'll also ask about the lost amount of victims or the victim's spouse's time from work, lost wages, money recouped from workers' compensation, or state or private disability insurance. And I know that's a lot to take in, but I think what it boils down to is attorneys will often be asking our clients very detailed, very specific questions, and we may not always understand why they're asking those specific detailed questions of our clients, but if we can let our clients know ahead of time that that's what they should expect and then be there as a source of support, it can help lessen some of that re-traumatization that often takes place when victims are being interviewed, whether it's by law enforcement or by other systems professionals.
Yeah, one thing to note too that I didn't mention earlier, and I'm sorry because I was meaning to, is so you don't need an attorney to go through the administrative process with the EEOC or the MDHR. You can just do that on your own as a citizen of this state. You know, you have the right to go file a complaint with either of them. That being said, there are a lot of attorneys that want to know and participate in that first process because the same kind of information that's shared there is likely going to be what is eventually used in a in a harassment lawsuit. So the sooner you can get folks connected with attorneys, the better. There are employment attorneys that do take on matters without having to take a fee from clients because there are some certain fee shifting provisions in the law that make it easier for attorneys to take these cases on. And so just keeping that in mind of they're going to need to do a lot of this deep dive on exactly what occurred, when it occurred, who was there, how it was, how it was witnessed, all of that stuff really quickly after the incidents are occurring. And in particular, if it's an assault in the workplace, that's a really challenging thing to do. So just trying to prepare them ahead of time before they do some of those intake conversations is great.
Okay, so we are going to move on to the community engagement and culture change piece. We do want to make sure we have some time at the end to go through some scenarios that we have with all of you. So I'll go through this next part pretty quickly. It's mostly pretty quickly because as advocates, we're familiar with this terminology, but when we're thinking about doing awareness and outreach education with employers in our community, they very often, I have found, are not aware of the terminology around awareness, outreach, risk reduction, and primary prevention. So we'll just quickly go through how we might talk to employers, employees, and their supervisors about sexual harassment in the workplace and different strategies for awareness and outreach. So as we're thinking about awareness and outreach, obviously that's telling the community about sexual violence and where to access services for victims. So I think oftentimes when we're talking to community members about the work that we do as advocates, their minds automatically will jump to, oh, you support survivors of sexual assault, you support survivors of domestic violence, but their minds don't always make that leap to, oh, you're supporting survivors of sexual harassment in the workplace as well. And so one of the things that we can do to help community members know about those services is to do some more awareness and outreach. We're, as advocate agencies, we're very often doing tabling and trainings anyways. Why not put out a flyer about the services that you can provide for workplace sexual harassment? Tweet about it on your social media accounts. Make flyers and ask employers to put them in places that are visible to their employees. Make it known that you do have trainings available around supporting survivors in the workplace. And if you're not sure how to do those trainings, you know that you can always refer to Standpoint to do those trainings as well. I think it's important to talk always with well, anybody really when we're doing prevention education, but specific to workplace sexual harassment, it's really important to identify for employers the differences between risk reduction and primary prevention. So we know, of course, that risk reduction is teaching individuals the skills to reduce their risk of being victimized, and that is things like employers telling employees to watch their drinks at office parties or to be careful not to drink too much or to use the buddy system, or not be in the office alone late at night, or not to wear anything too revealing to work. And while all of those are certainly techniques that we can use to make ourselves feel safer, they're not going to prevent sexual harassment from happening, whether it's in the workplace or outside of the workplace. But many people use that still as their go-to when they're doing education. And so if we can start educating employers about primary prevention techniques, so actually changing and addressing the underlying causes of sexual violence to begin with, that's going to be a much more effective way to do your outreach and education. So looking at things like primary prevention would be creating clear policies on stalking and harassment in the workplace. I think training folks in the workplace to recognize the signs of stalking and harassment is really key. I think oftentimes workplace sexual harassment can take place in more subtle ways than necessarily what we generally think of as the harassment that's happening on the street, right? Where people are shouting out things to people walking down the street. And workplace sexual harassment might be a little bit more subtle. There might be emails sent around. There might be a group workspace where chats are happening that are inappropriate. Holding perpetrators accountable, creating bystander intervention programs, and lastly, creating a culture of respect. And these are very simple things to talk to employers about, but I have found in my recent training experiences that there are things employers don't often have time to think about.
Yeah, Tracy, the distinction between risk reduction and primary prevention is a really important one, and it reminds me of part of my training when I was baby attorney. Um, I attended a training where it wasn't focused specifically on how to avoid sexual harassment in the workplace, but it was very much a training geared towards this young group of new attorneys about how women would be taken more seriously if they were in pants or in skirts and blazers rather than pants, or hair pulled back up off your face, or not touching your hair when you were sitting there talking with a judge or speaking with an older partner, which in most instances are older male partners. So there was just this really very clear message to us that we were the ones that were in control and that had responsibility for how we were perceived in the workplace, with absolutely no focus on how do we address these biases and these thoughts and behaviors that are already being perpetrated by those that are in charge and those that are really running the law firm, and how damaging those are. So granted, this was in 2007 at the time, so I would hope that many of our law firms in the legal space have come a long way since then, but it's still very much a way that a lot of the world operates is how do we control that individual person's behavior so they aren't targeted, instead of the bigger picture of how do we really change this culture and address these really embedded biases that we have. And the next slide here is something that I wanted to just touch on quickly with all of you. It's from the Stop Street Harassment Study. It's the most recent study I've seen done, and also a really expansive one where they interviewed and questioned 1,000 women and 1,000 men, men identifying, women, female identifying. They did not actually go into detail on non-binary genders, and that's a concern I have about the study. But they still got some really good information and representation that most of the time when people are experiencing harassment, they change their behavior, as I mentioned before. Oftentimes they are doing things, they're quitting jobs, they're leaving certain community spaces, right? They're changing their routes, their schedule to walk to work, or where they're going in the office, right? They're doing a lot of different stuff to try to, again, reduce their risk. And ultimately, only 1% of both men and women who were asked actually said that they confronted their harasser. And I was floored by that statistic, because we're not talking about somebody who is quote unquote dangerous or violent. We are talking about individuals who are just using their words in a demeaning, derogatory way, an offensive way in a lot of instances. And still, even then, people are not confronting their harassers. And what I attribute this to is, again, there are so many people who sanction the offensive, inappropriate, derogatory, demeaning stuff because they sit there in these meetings and they hear it and they say nothing. And that lack of taking sides, that lack of standing up and saying this isn't okay by supervisors as well as just colleagues alike is contributing to only 1% of us actually doing anything about it.
Great. So we're just going to quickly go over some tips for allies in the bystander intervention programming that you might be doing with local employers. So obviously we want to teach colleagues that it's okay to disrupt situations of sexual harassment that they see happening or about to be happening. So that could be if you are in the lunchroom one day and you overhear a bunch of coworkers making inappropriate comments, saying, hey, I don't feel like that's an appropriate comment for you to be making here. Maybe you could just change topics, making sure that colleagues know it's okay to ask victims how they're doing. Obviously, we don't want to pry or make a victim share any details that they're not comfortable with, but simply letting somebody who's experienced workplace sexual harassment know that you're there as a source of support can go a really long way. And then last but not least, we had mentioned this earlier, but if you are a colleague and you are seeing harassment take place in the workplace, making sure that you document that as well, even if you aren't the victim. That can often help make a case for why this has become a cultural norm in the workplace. In terms of bystander intervention and speaking to the harasser, we've just got a couple of techniques that we would invite you to share as well when you are going out and doing outreach with local employers, making sure that they're familiar with the use of I statements, i.e., hey John, I felt really uncomfortable and worried when I heard the comment you made to Lauren during our last all hands meeting. Instead of, hey John, you're being offensive, right? So we don't want to put people necessarily on the defense. That is not the way to engage them and to make them listen to what we're actually saying. Rather saying I statements is going to make them less on the defense and more responsive. Usually using casual statements, that's not appropriate. You could act confused. I don't really understand. What do you mean by that? Or you could paraphrase. Did I hear you say that we should hire her because she's hot? So are you actually saying that we should hire people based on their looks rather than qualifications? So these are all tools and techniques that you can use as an advocate when you're going out and doing education and outreach around workplace sexual harassment. Oftentimes we are talking to supervisors about how they respond to it, but we sometimes forget we need to talk to everybody in the workplace. So how do we talk to the colleagues who might be witnessing the harassment in the moment? And then we have one last slide that Amy wants to talk about, and then we'll quick go into some scenarios for you.
Yeah, so this is just, I'm not going to actually play the video now, but this is a video of an occurrence that it actually happened where it was happening in public. This isn't workplace harassment, but I think it still applies and can be used as a really effective training tool. So essentially what is going on is there's an altercation between two individuals on the New York subway. There's actually a physical altercation, which, that's dangerous to intervene in anyway, but regardless, what this individual did is this guy who was watching was eating some chips. And so he just stepped right on in between the two individuals and just kept on eating. He didn't engage anybody, but he was very effective at disrupting it and interfering in it. And so he was a physical barrier between what was going on between the two individuals. And in the workplace context, maybe what that looks like is you overhear a conversation where somebody is being derogatory or telling an offensive joke or really inappropriate with somebody. It's walking in and saying, hey, Janelle, I'm running to get coffee. Would you like to come with me? Right? It just talks that little ability to just separate the person who's being targeted can go a long way. And there are two other instances of bystander intervention that are captured on this video. You should look it up when you have a chance. It's also just really interesting. There's one woman who does directly confront the harasser, and she's saying, you need to stop following this woman. You need to stop following. She doesn't want you to be here. So there's that tactic, the direct confrontation. But then there's another one where the person who's actually shooting this video, you can hear him say, I've got you on video, it's effectively saying, we can hold you accountable if something more happens. So it's that documentation piece that's so critical that all colleagues can be engaging in. So let's go into a scenario. Do you want to read this to you, Tracy, and then you can talk it out from the advocacy perspective? What do you think?
Sure. I was just going to preface by saying, so we have quite a few scenarios and quite a few slides at the end of this webinar that are intended to be tools and techniques for you all to use as well. So in addition to the scenarios, we have slides that that you are able to take back to your team at your agency and to think about the types of awareness and outreach you're already doing, but also how you might expand the awareness and outreach around the services you provide around sexual harassment in the workplace. So let's go ahead and start with this first scenario. You want to take it away, Amy?
Sure.
Okay.
So, advocacy organization, you get a call on the crisis line, and it's from a local supervisor. They tell you that they supervise a small team, but it's staff within a larger company, and they've worked with most of these staff members for a number of years, so they know them really well. Recently, a staff member who was transferred into their department, and this staff member, having been at the company for a very long time, almost 2 decades, continually refers to colleagues as hun or dear. And the supervisor has tried to address this with the employee who's using this language during just a one-on-one meeting, but they were told that, it's just the way that I was raised to talk. I'm from the South. This is how everyone talks down there. I'm not being offensive. This is just what I say. So the supervisor wants to know, what do you do now? What options can you as an advocate provide them with?
And so we'd like to invite you all to go ahead and type your thoughts and ideas into the chat function. We'll give it just a minute, and Ty will let us know if there's any responses, but then we're also happy to talk through some options that you might have.
All right, and after I see some posts, I will read them off.
And so as we wait, I think it's important to note that Amy and I actually talked quite a bit about these scenarios when we were crafting this webinar, because these are often questions that we as advocates will get. And does it necessarily constitute workplace sexual harassment is one of the issues that Amy and I had talked about. And on its surface, some of these don't constitute workplace sexual harassment. They may be uncomfortable for the employee that's experiencing those comments, but are they enough to take forward a claim of workplace sexual harassment? And that's not necessarily the case with all of those. Amy, I don't know if you want to weigh in just a little bit on that.
Yeah, I mean, the burden of proving sexual harassment, in particular hostile work environment sexual harassment, which is what this would potentially fall under, is really hard because a court's going to look at, and the EEOC or the MDHR is going to look at the context in which the statement's being made, the relationship between the two parties. They're going to dig into how long has this been going on, how pervasive is this, is there any other conduct that's looked at, because it's a holistic view of what's happening. If these are statements that are just being made in isolation by an employee who doesn't have control over the other person that they're talking to, it may not constitute actionable sexual harassment. That being said, there is still support that an advocacy organization can provide, and I would argue there is absolutely still action that an employer should be taking to nip this in the bud so that this doesn't grow to be a bigger thing that then is actionable harassment.
Absolutely. And I think, as an advocate, if you're getting this call from the supervisor, there's a number of different options that you can provide them with. So it sounds like in this scenario, it's a smaller team of staff within a larger company, and the person calling you is the supervisor of this one employee. Can they go up in the chain, right? Is there somebody higher up that they can report to that may be able to hold this person more accountable than they are? Is there a way to talk with the staff member who is experiencing the Huns or the deers all the time to let them know that they should feel empowered to let this employee know that they don't like being called Hun or deer? So I think there's a lot of ways that we as advocates could support this employer contacting the advocacy agency. Let's go
And
into
I
go
have
ahead,
a
Ty.
comment from one of the participants. Remind the employee that not everyone wants to be addressed as hun or dear, and that even if it isn't their intent to be offensive, they may still be saying offensive things and have no right to act that way toward other employees.
I
They can
love
use,
that idea.
yeah,
Gold star. Way to
and they
go.
can,
That's it.
and let me see, they can use terms of endearment all they'd like outside of work, but using terms of endearment with someone with whom you don't have a personal relationship can make folks feel uncomfortable.
You advocates are experts already. This is great.
Mhm.
And I think what you're really hitting on in those comments is the idea of intent versus impact. So we know that likely the staff member who is using this terminology is not intending to make people feel uncomfortable as they told their supervisor. It's how they were raised to talk, but talking with them about the impact that their language is having on their colleagues, I think could make a really big difference. So thank you all for weighing in. Let's go to one more scenario. So this one is you have a client who was working after hours one evening. A senior colleague, but not a supervisor, approached them and asked if they wanted to get together later that night. Your client was hesitant to say no, as they've heard from others that this person likes to get their way and can stand in the way of promotions and raises. Now your client keeps receiving texts and emails from this person. What options can you provide them with?
So we'll give it a minute for you incredible advocates to write in what your thoughts are. And I think one thing that is also a theme that does crop up a lot in the sexual harassment counseling that we do here at Standpoint too is a lot of people aren't really sure how to navigate the workplace relationship as well. Some employers take the route of just prohibiting them, right? There might actually be something like that controls. Sometimes employers might prohibit a relationship or prevent it from happening to limit it from happening if the person has control over the other person, like if they're in a position of authority. But in a lot of instances, and in particular in our smaller communities, a lot of the time there might only be one or two large employers in the area. And so oftentimes folks do work for the same company. And it gets complicated and it can get messy. And in particular, if one individual in the relationship is using their power and coercing the other into either engaging in that relationship, that is absolutely behavior that is prohibited under the law, as well as I would imagine employee policy. So just thinking through those reasons as well, or those controlling protections as well, as you're continuing to think through your ways to advise them.
And I think as advocates, thinking about how can we safety plan with this client? So they mentioned that they do have to work after hours. Are we safety planning with them to make sure that they are feeling safe in that environment when they do have to do that? Is there a way for them to avoid the person that is making them uncomfortable, or to have somebody with them so that they are not feeling alone with the person that's harming them? Ty, any responses to this one?
No, not yet.
Okay. Okay. Well, feel free to let them roll in as you'd like, but I recognize that we only have a couple of minutes left and we really would love to allow some time for questions. So if anybody has any questions, now is the time. You can definitely skip through the other slides in the PowerPoint. You'll see we included one more scenario for you. We included a sort of action plan for your organization, as well as a lot of resources that you can use, both to learn about sexual harassment in the workplace, but also to help when you're doing education and outreach with local employers in your area.
And while we allow some of those questions and responses to come in, I just want to say one thing about this last scenario that we had just talked through. So I can imagine clients of yours being very challenged by this one because they don't want to suffer any negative consequences if they rebuff the advances of the senior colleague. So really empowering them and helping them to craft a response that is respectful to the extent that this is not a sexual advance, right? But also very clear in establishing boundaries is absolutely something that would be an appropriate response here. And I would just caution or encourage actually everyone to ensure that they're doing these sorts of things in writing, because it does serve to be a possible record and assist the person with reconstructing the situation after the fact.
Okay, Amy, I do have a question. So someone asked, is there any advantage or disadvantage to filing a claim with both the MDHR and EEOC?
That is a great question, and I appreciate it because you do not have to file with both. You actually only should file with one. These two organizations, because they cover, MDHR is really about the state law, Title VII is about the federal law, but both of these laws really control the same kind of behavior. So they have what's called a cross-filing mechanism. So if you file with one, it means you have the right and the authority to use either the federal or the Minnesota Human Rights Act law to support your claim. I actually usually make the recommendation to file with MDHR if given the option. First, because the timeline is a little bit longer, so that's helpful. It's 1 year instead of 300 days. But also, our Minnesota Human Rights Act is actually a little bit more expansive than the federal Title VII law in terms of the kinds of behavior it prohibits. So I find that it's oftentimes just a better framework for clients to be dealing with.
And I have another question. If the sexual harassment happens on a reservation, should they still report to MDHR and the EEOC?
It would depend on who the employer is. I would imagine if we're dealing with a tribal employer, that actually, I don't know. I would expect that tribal law controls that. And I am just not as familiar about what protections tribal law has in it when it comes to workplace sexual harassment. If it's a federal or a state, if it's a non-tribal employer, the location is not really going to be controlled because the law still applies to them, right? So the Minnesota Human Rights Act still applies to an employer that is incorporated under either our state or our federal laws. So if you have questions about these kinds of things, absolutely give me and Standpoint a call, and we can dig into it to try to help figure out exactly what kind of law is controlling and who does it protect.
No more questions.
All right, well, with that being said, I think we're going to wrap up for today. We want to thank you all for participating in this webinar. And again, we encourage you to reach out to Standpoint with any additional questions that you have about workplace sexual harassment. Wanting to remind you all again, too, that Standpoint staff is available to come do trainings as well. All right, thanks, everyone.
Thanks very much.